There are two key things you need to know about the concept of at-will employment in California. Number one, you're generally presumed to be an at-will employee unless specified otherwise in some kind of document or an agreement. And three of the most common situations where a worker is not an at-will employee are: number one, if you have an employment contract with your employer that states that you're guaranteed employment through a certain date and you cannot be terminated unless there is just cause for that termination. The second situation is where you're a member of a union and you have a union agreement or a collective bargaining agreement that usually states the same thing, that you cannot be terminated unless there is just cause. And just cause usually means something relatively serious. It has to be a serious mistake, a serious and repeated violation, or some kind of serious insubordination. It cannot be something small or petty. And the third situation where you're likely not an at-will employee is if you're a government worker, if you work for a city, county, state, or even federal government. This is because most government workers, after they go through a probationary period, they attain a level of permanence. They become so-called permanent civil service servants. And not only can they not be terminated without just cause, but they're also entitled to all kinds of hearings and appeals before their termination becomes final. This includes CalHR hearings and meetings at a state level, Coleman hearings, Scaly hearings, SPB hearings, PRB hearings, and all kinds of other appeal mechanisms that might be available to those government workers. Otherwise, if you're like most people in the private sector and you're in fact an at-will employee, this means that you can be terminated for any reason or no reason or arbitrary reason, fairly or unfairly, with a couple of exceptions that I will be talking about in a moment. At the same time, if you're an at-will employee, you also have the freedom to resign and to quit your job for any reason or no reason, with or without notice. Now, even though there is a presumption of at-will employment, which means that if you don't have any papers and any documents that between you and the employer that talk about your employment status, you will generally be considered an at-will employee. Most employers still want to play it safe, and they will have you sign an acknowledgement that you are in fact an at-will employee and that there is no question, there is no ambiguity about it. The second key thing that you need to know about at-will employment, and this is something that a lot of employers don't know or misunderstand and trip up on and get in trouble for, is that even though you can be terminated for any reason or no reason, terminating you for discriminatory or retaliatory reason is still going to be illegal, and it will give rise to a wrongful termination case, discrimination case, retaliation case, and so forth. So, if there is sufficient evidence that the real reason or one of the real reasons for your termination is discrimination, meaning because of your age, disability, race, religion, sexual orientation, age, familial status, and so forth, or if there is evidence that your termination is retaliatory, meaning because you complained about unlawful harassment, safety violations, crimes, embezzlement, violence, threats of violence, and a number of other so-called protected activities, your termination will be illegal. And the fact that you're an at-will employee does not change that. So these are the two key things that you need to know, whether you're an employee or an employer, and especially if you are an employee. Thank you.